Please be seated. You got all of them? Yep. Okay.
Attorneys are present. Defense is ready, or do you need a moment? Okay, all four defense counsel are present, and Mr. Rodgers.
Go ahead, sir.
Other than the
We might, I'm sorry, because you're already brought in. Can we just resolve this issue?
I was just getting ready to say, other than the outstanding issue, is there anything else? Okay. Anything either side wants to add?
Yes, Your Honor.
Okay.
Good. We have a case that indicates that the issue here.
Thank you.
State of Florida versus Horowitz. That's 191 Southern 3rd, 429. It's the Supreme Court of Florida case from 2016. Judge, in that case. Oh, sure. Must be becoming soft-spoken in my old age. Judge, in this case, the defendant was convicted of first-degree murder with a firearm. During the trial, the state repeatedly elicited testimony from law enforcement witnesses that the defendant remained silent following the murder, but prior to her formal arrest. The state then emphasized this silence in closing argument by arguing that the jury could consider the defendant's pre-arrest, pre-Miranda silence as evidence of her consciousness of guilt. That is precisely the argument that the state made when we were arguing our objection at the bench, that the state was trying to establish consciousness of guilt. With respect to Mr. Rodgers, the court found that the pre-Miranda silence as substantive evidence of guilt when the defendant has not testified at trial was unconstitutional. The Fourth District Court of Appeal concluded that the state could not use evidence of this silence as substantive evidence of guilt, and the issue was therefore certified.
These are the other copies of the forwards. I'm guessing one of those is for us.
We are working on that right now.
State needs a moment.
No, Your Honor. The issue in the instant case, in the case of State of Florida versus Rodgers, is distinguishable. A little bit of Horvitz I was able to read while I was standing here. We're not using Mr. Rodgers' invocation. We're not using any pre-arrest, pre-Miranda silence. It's actually the opposite. He wasn't silent. He spoke. He just wouldn't allow the detective to record the statement. And that's what the issue is. The issue is not that he refused to talk. He did talk. You heard the testimony. There was a conversation. It was voluntary. We put in the evidence of the voluntariness of the statement. So the issue is not whether or not he remained silent. It's not our position that he remained silent. He did at some point, ask not to talk, which we agree. It's not admissible. It's not relevant. What is relevant is when the officer wanted to record Mr. Rodgers' discussion, Mr. Rodgers refused to be recorded, but wanted to have a conversation, which they did. And that's what the issue is. And our situation is distinguishable from counsel's recitation of the facts in Horvitz. I do have, and I apologize to the court because I was in the process of printing it, and we were both printing, so my copies, I think, went somewhere. But I have Fernandez. Now here, this issue is a case where a defendant waived Miranda. However, the detective who was questioning him wanted to formalize the statement by recording it. And the defendant would not allow it to be recorded. Now, it's not completely on all fours, again, with our instant situation, but here the third DCA says the defendant's refusal to formalize the statement is admissible. Here, the defendant waived Miranda and agreed to talk. In our instant situation, there was no Miranda given because the defendant was not in custody. There was no need to Mirandize him. However, he had agreed to talk. and refused, after agreeing to talk, to allow the officer to formalize it with a recording. And that's what the issue is in our instant case of State v. Rodgers. We would respectfully submit that the defendant's refusal to allow the recording is admissible. However, his indication towards the end of the conversation that he did not want to talk anymore is not admissible. I'm sorry, and I didn't cite Fernandez. It's Fernandez, 786 Southern 2nd, 38, 2001, 3rd District Court of Appeal.
Okay.
Judge, again, this is done. This question was asked to whether or not to record when Mr. Rodgers had absolutely no obligation to speak to the police.
Okay. Wasn't didn't you ask him if, I could have sworn that you said that you asked him whether or not he would give a sworn recorded statement, not just a recorded statement, or am I recalling that incorrectly?
I think in front of the jury, the question was recorded statement, but I think in our proffer, Lieutenant Lebid said sworn recorded statement. And I have to defer to the record, but I know it was slightly different. The question, I asked a slightly leading question when the jury was in the box, and I asked a more open-ended question during the proffer.
Judge, could we have
We'll let the stenographer take a look. We'll give her a moment, see if she can pull up exactly what was asked in front of the jury. Sorry.
Question, were you able to make a recording of that discussion? Answer, no. Question, why not? Answer, he refused to provide a sworn taped statement. Is that all you need?
Yes, ma'am. Just let me know when you're ready again.
I'm ready now.
Okay. Anything else?
Judge, based on that statement from Lieutenant Lebid, he has not testified in this trial. That's being offered as substantive evidence, and we are asking that we're moving for a mistrial in this case. I would also like to cite Smith versus State, 754 South 2nd, 54. That's a 3rd DCA case. Judge, in that case, the defendant responded to a few initial questions and then refused to give a stenographic statement. The Smith panel viewed the record. Smith was not being asked to memorialize what he had already said. Instead, Smith was being asked to make a further statement before the stenographer. Refusing to do so, he did invoke the right of silence. We feel that this is an improper comment on the defendant's right to remain silent.
Okay. Your objection's noted for the record, overruled. I'm going to deny your motion for a mistrial at this point. I'm going to instruct the state that they can to move on from this line of questioning, 1. 2, if it's brought up again, I would steer away from anything about a sworn statement. Just if he declines, he declines.
Yes, Judge. And will the court allow the state to inquire into the discussion that the lieutenant had with the defendant prior to being asked to provide the recording?
Yes, sir.
Okay. I'd like to make sure that I've admonished the witness not to mention that the defendant, at the end of the statement, indicated he did not want to talk anymore.
We go through what you're exactly going to ask your witness here at the very end again.
The question that I want to ask is, did you have an opportunity to talk to the defendant? Yes. Were you able to record the discussion? No, he refused to record recording.
I think that's already, that cat's already out of the box, isn't it?
Well, yes, but the objection from the record, I think if you read that record where the objection started, I never got to go further when the officer said he refused to provide a recorded tape statement. Well, yes, but he did make a statement, and I think that's the part that's not on the record before the jury, that I want to make the record, that he did provide a statement. It just wasn't sworn, it just wasn't recorded in tape.
Well, I think all you need to do then is ask him, did he make a statement?
Okay.
And Judge, again,
Right.
I'm sorry,
Go ahead.
that the cat is out of the bag, and that's why we're moving for a mistrial.
And I denied that. Okay. State's ready?
Yes, Judge, if the court will give me a little bit of leeway to lead the witness through this portion of the testimony,
Sure.
so we don't step on a mic.
I imagine you only have, what, like 3 questions tops?
Yes, Your Honor.
Okay. Who's next after this witness?
Mr. Lebid, Your Honor.
How many more do you have lined up for today?
We have several more in the back, and some more records and things coming in.
Okay.
And there's at least 6 more, I think, back there. We didn't want to run out of witnesses again before the end of the day, but we didn't necessarily want to have a bunch of witnesses left over at the end of the day.
We still looking at 91?
Exhibit 91?
No, we still looking at 91 witnesses.
Oh,
I'm trying to get an idea of where we're at.
we've pared down the witness, we have pared down the witness list based on what's come in so far. I don't expect that we'll hear from 91 witnesses.
Roughly how many?
Can you give us a
Give me
moment?
a moment, Your Honor.
Sure, I'm just curious because I want to see where we're at scheduling-wise. Although, I mean, I guess that doesn't give me an idea of how long each one will be, but I'll have a better idea roughly.
What if we knew who they were? Can we say about 25?
Okay. Yeah, you can say whatever. You're the only ones who know. I mean, I can't
No,
say.
I'm trying to quickly assess, Your Honor, so I want to be as accurate as possible.
I just wanted a ballpark idea
Yeah.
because you read 91 at, when we were picking the jury and we're through about 18 and we burned half a day yesterday, so I'm just trying to get an idea where we're at. So I know if I have to cancel more of my stuff later in the month. Okay. Bring them out. Again, did you follow my instructions, not talk about the case among yourselves or with anybody else, or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. And you're still under oath, sir.
Thank you.
State.
Okay, Lieutenant, let's go back to your visit with Mr. Rodgers and Ms. Schumacher at their home. Now, you had an opportunity to have a discussion with Mr. Rodgers.
Yes.
And in typical fashion, you asked to record your discussion with him.
Yes.
And he refused to allow the recording,
Yes.
but you did have the discussion.
Yes.
Did you have an opportunity to ask Mr. Rodgers about whether or not he went to Florida?
Yes.
And what did he tell you?
He said that he did not.
Did he mention going down there for graduation?
No.
Now, you told us earlier that you had Mr. Rodgers in Mr. Rodgers' phone number in Mr. Wright's cell phone records. Did you have an opportunity to ask Mr. Rodgers about whether or not he had been in communication with Mr. Wright?
Yes.
And what did he tell you about that communication?
That he didn't talk to him that often.
Did the records indicate differently to you?
Yes.
With the time that you were having this discussion, had you told Mr. Rodgers that you had the cell phone records?
Yes.
prior to the discussion with Mr. Rodgers, did you offer him anything to get him to talk to you?
No.
Did you coerce him or force him to talk to you in any way?
No.
At the time of the discussion, was he restricted, his movement restricted in any way?
No.
And this is still at his home.
Yes.
And after your discussion with Mr. Rodgers, you and Lieutenant Downs left,
Yes.
and Mr. Rodgers stayed at home with his girlfriend.
When we left, he was still present. Yes.
Did you have an opportunity to speak with his girlfriend during that visit?
Yes.
Was she cooperative?
To a degree.
Did you leave Mr. Rodgers and Ms. Schumacher with information on how they could contact you if they had additional information?
Yes.
Did you hear from Ms. Schumacher again?
Eventually, we spoke with her again.
And when did you speak with her again?
The next time I encountered Miss Schumacher was in the month of August.
And did you have a discussion with her at that time?
I did not.
Downs did.
Yes.
On the day you visited with Mr. Rodgers and Miss Schumacher, Taylor Schumacher, did you or Downs threaten her in any way?
No.
Did you offer her any money?
No.
At some point, Ms. Taylor re-engaged your investigative team about Mr. Rodgers.
Yes.
Did anybody offer her any money to re-engage you?
No.
Did she eventually make a formal statement?
Yes.
Was she given any money for that statement?
No.
Was she promised any money for the statement?
No.
Now, moving ahead to on about September 10th, 2015. Did you make a subsequent? Did you make a subsequent opportunity to make contact with Mr. Rodgers
Yes.
to talk to him some more about the case?
Yes.
And did you encounter you encountered Mr. Rodgers in a facility?
Yes.
Objection, Your Honor. Can we approach?
Yes, sir. I'm going to instruct that you not talk about the case among yourselves with anybody else, and I'll be with you all momentarily. Please be seated. Okay, finish your line of questioning with this witness.
And Judge, if I may, I'm going to ask more open-ended questions
Sure.
and establish the full facts and then argue about what should be admitted and what shouldn't be admitted, if that's okay with the court.
Yes, sir.
Okay. Lieutenant, let's back up then. At some point between your initial discussion with Mr. Rodgers and your September 10th discussion, did you become aware that Mr. Rodgers was on probation in Missouri?
Yes.
And in fact, during your investigation, did you provide information about his whereabouts to his probation officer?
Yes.
Rather specifically, his whereabouts on June 28, 2015.
Yes.
And as a result of providing that information to his probation officer, what happened to Mr. Rodgers?
They violated his probation, swore out a warrant.
And was he on state or federal probation at the time?
Federal.
And so when he violated his probation, was he given a sentence of any kind?
I don't recall.
Well, let's move forward to September 10th. Where was he when you encountered him on September 10th?
In a holding facility.
And where was that facility located?
I believe it was St. Charles, Missouri.
And at the time, had he yet been charged with Florida charges?
No. Or I'm trying to remember the exact date of the warrant for Rodgers' arrest for our charges. I don't recall at this exact moment. If I could refer to my paperwork, I could tell you.
Sure.
I think it was August, but let me double check.
Sure.
August 27th is my recollection for when we were able to formally process warrants for him.
So August 27th. All right, so Mr. Rodgers, however, was being held on federal charges.
Yes.
But there were also some state charges from Florida out there as well.
Yes.
And when you went to this holding facility, was that some type of a jail or prison facility where you went?
Yes.
And Mr. Rodgers was in the facility?
Yes.
Were you able to take him out of the facility to talk to him and then bring him back into the facility?
No.
You had to go inside the facility to talk to him?
Yes.
When you got inside the facility, did you expect to have a contact visit with Mr. Rodgers?
Yes.
And can you explain to the court what the difference would be between a contact visit and a no contact visit?
A contact visit, by my understanding, is that he would be brought into a room physically where I could actually sit in the same room and be in his physical presence versus being behind some kind of screen or some kind of protective film.
And so when you got to the facility, you weren't able to have a contact visit with him.
Correct.
And so can you describe to the court did you have a visit with him?
Yes.
Can you describe to the court how that went?
Myself and Detective Downs were escorted to a floor and brought into a room that had a table and chairs, and there was a small clear glass window in the background, but we were led to believe that the reason why there's a table and chairs is that this is where we would be sitting with Mr. Rodgers. So as we were going in there to set up, and when I mean set up, move the chairs, have our digital recorder going, while we were about to start that process, Mr. Rodgers was suddenly in front of that glass window, unexpectedly. It appeared to be unexpected for him also, because when we first saw him, he began demanding of us at a very loud voice, "What are you doing here? What's going on? Why am I here? You better tell me."
Did you tell him why you were there?
Yes.
And at this time when you told him why you were there, you're still outside of whatever. When you say there's a window, were you able to go around the window and make contact with him?
No, the room we were in had 4 walls, and the window was affixed to one of those walls to where we could not be in his physical presence at all. And it was a average-sized window where we could kind of see from, I'd say, mid-shoulder to a little bit above his head, and a little bit wider than an average-sized person, but nothing significant.
So you couldn't get in and he couldn't get out.
Correct.
And so after he's yelling about, you said in a loud voice, about why you were here, did you tell him why you were there?
Yes.
And what is it that you said to him?
Right before what I said to him, so this makes sense to you all, he said, "You better tell me why I'm here or I'm leaving." And I said, "You're being charged. You saw what you were charged with. It's homicide, second-degree murder."
And after you said that to him, you told him why you were there. What did he do?
He said to us, "Well, in the state of Missouri, second-degree murders, 15 to 20 years, and I'm okay with that." And before I could say another word, he walked out of view.
And after he walked out of view, did you have an opportunity to finish, to even set up and do the interview with him that you'd come to do?
No, that ended our contact.
Judge, that's our proper proffer of the full circumstances of the contact. I believe we made a record of the contact at the suppression hearing, the prior suppression hearing.
Well, and I've already ruled this statement can come in. I think they're just objecting to the manner in which it's being presented, correct?
Yes, Judge. I mean, there's absolutely, as I said, no reason to be discussing where this conversation was held. There's already been a ruling on the statement itself. But Mr. Hunter, to bring that up and then use as a justification for that, the fact that he brought it up in his opening, is just unacceptable.
But I can speak for myself. I wasn't justifying anything. I was simply making a point that this is not the first time we've heard the circumstances. And again,
You're saying it's not a surprise. It shouldn't be a surprise.
correct. And again, certainly, Your Honor, we submit to the court respectfully that the circumstances of why he's in the facility are not relevant, are prejudicial. We don't necessarily want to discuss why he's in there. We don't want to discuss him being on probation. We've had that discussion with the witness. But the only way to give that discussion context, the defendant appearing behind a window, yelling, and then walking away, and the detectives can't talk to him, there has to be some explanation to the jury that this wasn't a normal conversation. And the only way to explain that is to say he was in a facility. There's no other way to, like, you can't lie to the jury. There's no other way to explain the circumstances other than the limited reference to being in a facility. It's inextricably, I'm not finished, it's inextricably intertwined with the facts.
Okay, defense.
Judge, he makes the argument, if you can't say that he was on probation, you can't say that he's serving a sentence, but we can say he's in a facility to give it context. That doesn't make any sense. These things they're totally prejudicial. There's no reason to bring them up. And whether he was in a facility, if he wants to say he walked away from him, he can't walk away from him outside of a facility.
That's a half-truth.
Well, I'm going to stop you guys there. I mean, of course, it's prejudicial. The question is it does its relevance outweigh its prejudicial value, as well as, is it intertwined with it to the point that it won't make sense? So I'm going to think about it a minute. I'll be back in like 5 minutes.
All right.
That's all right. It's all right. You ready? Okay, we'll go back on record. We have both assistant state attorneys present, all four defense counsel, and Mr. Rodgers. Your objection's noted for the record, overruled. I don't think there's any other way to really present it and cull it out to where it makes any sense.
Judge, if I might.
Sure.
If the statement is so intertwined with his location, then how can that statement possibly be admitted?
We've already had a motion on that in the ruling, so that is what it is.
Then if I might have to move on to my next topic, if I could, we would have to move for mistrial at this time, Judge, because it's going to be impossible now for Mr. Rodgers to get a fair trial. The media is running all over now with the story that he was on probation or in a facility or.
I'm fairly certain the media probably already knew that. I don't read the paper. I don't really watch the TV other than cable show here or there, but my guess would be, from my prior experiences, that they probably already knew that, and that's been reported numerous times, which is, we've already gone through that with the jurors when we picked them, and I think that's a non-issue because I've instructed the jurors not to watch TV. Your objections noted for the record. Your motion for a mistrial is noted for the record and denied. Bring them out.
Before we bring the jury out.
Hold on.
Yes, sir.
I just want to add to my objection that this is highly prejudicial. The probative value of this statement is far outweighed by the prejudice of bringing in fact.
We've already litigated that issue, as I said before. We had the motion to suppress on the statement, and I already allowed it. Bring them out. Please be seated. I'll ask our jurors again, did you follow my instructions not talk about the case among yourselves with anybody else or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. State, you may continue.
Okay, Lieutenant. When you went to speak with Mr. Rodgers, you weren't able to actually sit down at a table and talk with him, right?
Correct.
He appeared behind a window.
Yes.
And can you demonstrate for the jury how big the window was?
It was an average-sized window. It was clear to where I could actually see through to the other side.
And were you able to see that Mr. Rodgers was standing behind the window?
Eventually, yes.
Was it apparent to you that he was able to see you from his side of the window?
Yes.
How did he react when he saw you?
He began to speak loudly, demanding to know why he was there, why I was there, what was going on.
And other than you, who else was there? Who else was there?
Detective Mike Downs?
Just the two of you.
Yes.
And did you tell Mr. Rodgers why you were there?
Eventually, yes.
Did he give you conditions? Did he tell you that if you didn't tell him why you were there, he was leaving?
Yes.
And did you tell him why you were there?
I did.
And explain to the jury how it was that you told Mr. Rodgers why you were there.
Through the course of the sudden contact from walking into this room and observing this window, while expecting to sit down at this table and
let me stop you, Lieutenant, and I want to make sure I want to ask a very narrow question. Did you tell Mr. Rodgers why you were there?
Yes.
What did you say to him?
We're here for a homicide, a second-degree murder.
Okay. And how did he respond when you said that to him?
Mr. Rodgers replied to me, well, in the state of Missouri.
Your objection is noted for the record, overruled.
What did he say to you when you told him that?
Mr. Rodgers replied to me, well, in the state of Missouri, second-degree murder is 15 to 20 years, and I'm okay with that.
And after he said that, what did he do?
He immediately left.
Your Honor, we tendered the witness.
Defense.
Sir?
You began your investigation in this case on June 30th of 2015, correct?
Yes,
And you were at the crime scene on Jarvis Road,
eventually.
eventually. When did you first go there?
June 30th would be my first day back to work for my days off and being briefed on the case. And then I'd say by possibly the 2nd of July is when I first went out to the crime scene, approximately.
And it was still a crime scene.
Yes.
When you arrived there, did you walk through the residence?
I did.
Were you in the kitchen?
Yes.
Was blood still present in the kitchen?
Yes.
You didn't observe any sign of a struggle in that house anywhere but in the kitchen, correct?
Correct.
Now, early in your investigation, you seized on Mark Sievers as a suspect, correct?
Mr. Sievers was one of many.
Okay, but he was a suspect.
Absolutely.
Okay. And that's because murders are committed primarily between people who know each other.
I can't say that.
That's not something you've encountered in your years of homicide investigations.
Objection, asked and answered.
Overruled.
During my years of homicide investigations, the reasons for how people know each other and what that lead to a homicide vary.
That's not my question. My question is, murders are primarily committed between people who know each other, people who love each other, correct?
Objection, asked and answered.
He hasn't answered the question.
Overruled.
From my approximate 7 years of doing this, it'd be hard to give you a percentage of how many are known offenders to each other. It kind of feels like maybe half to a little bit more than half for people that have some kind of knowledge of who they are, whether it be from being acquaintances all the way to loved ones like you suggested.
Your examination of the crime scene did not indicate to you that there was more than one assailant in this crime, correct?
Can you say that again, please?
Your examination of the kitchen area where this assault took place, there was no indication to you that there was more than one assailant.
Based on my visual observations, I could not safely say how many people participated in this event.
Okay. Now, as we said, by 2015, June of 2015, you had been to many homicide scenes.
A decent amount, yes.
You'd been at that time, you'd been a detective for how long?
Dealing with death investigation since January of 2013.
Okay. But you'd been a deputy for quite some time.
Yes.
You were a sergeant at that time.
Yes. 2015, June, yes.
You'd never investigated a murder for hire prior to that, had you?
I've had a couple reports of that I investigated where it was a conspiracy to commit, where we were trying to prevent it from happening, but a full completion, no.
Never actually investigated a homicide that was for hire that came to fruition.
Not that I was aware of by the end of the investigation, no.
Would you agree that a hammer is a messy murder weapon?
Can be.
And household tools like hammers are generally heat of passion weapons used in homicides where people, again, know each other, correct?
Objection, cause for speculation.
Sustained.
Now, we've heard testimony here that no items were removed from the home. Is that correct?
At the time, it was hard to say because we were preliminarily following up with the homeowner, the surviving homeowner, and we were trying to figure that out. But eventually, that cooperation ended. So initially, no, it didn't appear as if anything was taken.
Well, there was, your observation and what you were told by the other investigators indicated that there was a large sum of cash in the home, correct?
Yes.
Over in excess of $40,000.
Yes.
And it doesn't make any sense to stage a burglary or a robbery without, if you're going to stage it, makes no sense not to take valuables from that home, correct?
If you were going to successfully stage a crime, it would make sense to take valuables with you.
And was it your analysis of the scene when you first encountered it that this was an attack, this attack was spontaneous, and that the person who had committed the attack panicked and left?
My first impressions left me confused about how it evolved until I knew more through the week about when we were able to determine the time that our victim arrived home to when we located her.
But this was not an organized scene.
I think that depends on your perspective. If it was something that was trying to be staged, it could be considered semi-organized. You could look at it from two different sides, where you could say, yes, this is very organized, or no, not at all.
Well, I believe you just testified that if you were to stage a scene, you would take valuables from the home, correct?
What I testified to was if you were to successfully stage a crime, then yes, you should take valuables with you, so it would look like a completed burglary that became interrupted.
And that wasn't done here.
That's not what I saw.
Let's talk about Mr. Wright for a bit. After receiving information from Ms. Grunnert, you developed Curtis Wright as a suspect, correct?
Yes.
And over the course of several weeks, you ended up spending a lot of time with Mr. Wright.
Yes.
You observed that Mr. Wright appeared to have certain physical limitations.
That's what he claimed.
And did you observe them at all?
His gait was minimal to where it appeared that he maybe was trying to be careful about his movements. But other than that and verbally complaining, that was it.
Now, he was interviewed multiple times.
Yes.
Okay. And these interviews were all recorded, correct?
Yes.
Now, you and Detective Downs both felt that Mr. Wright was being deceptive, that he was lying to you.
Yes.
Now, Mr. Wright, in his multiple statements, finally admitted to beating Dr. Sievers, a 5'1" woman, with a hammer, correct?
I don't recall her exact height, but yes, he did admit to finally striking her with a hammer.
Right, the salient point of that question is that he beat this woman with a hammer.
Yes.
And he admitted that to you.
Yes, he did.
So, getting this violent sociopath to a point where he will
Objection.
admit.
Counsel is editorializing and testifying.
Sustained.
Getting Mr. Wright to a point where he would actually admit what he had done was more of a process than an event then.
Absolutely.
Now, you testified earlier that you had difficulty getting neighbors to say anything about Mr. Wright, correct, when you were in Missouri?
Correct.
Was that cleared up for you somewhat after Mr. Wright told you he had beaten this doctor to death in her kitchen?
No.
No. The fact that this person admitted he would hit another human being with a hammer didn't make you think, well, maybe that's why people aren't talking to him or talking to us about him. They're scared of him.
Objection, Your Honor, calls for speculation on the part of the witness.
Sustained.
Now, again, you believe Curtis Wright is a person who is selective in his use of the truth.
Objection, again, calls for speculation on the part of the witness.
Overruled. If he hasn't, he knows he can answer, I think he's got an answer.
Yes, I believe he's selective with the truth.
He's truthful when that's convenient for Mr. Wright.
I agree with that.
Now, as far as the relationship between Mr. Wright and Mr. Rodgers and Mr. Sievers, between Mr. Sievers and Mr. Wright, there were legitimate business transactions that you discovered during the course of your investigation, correct?
Yes,
But your investigation never generated any information indicating that money had changed hands between Mark Sievers and Curtis Wayne Wright to murder Dr. Sievers.
say that one more time, please.
There was never any information generated in your investigation to show that money passed between Mark Sievers and Curtis Wright to murder Dr. Sievers.
There was never anything directly explained. There was something that was implied.
Implied, but no actual evidence, no evidence for you to discuss here.
Correct.
And there's absolutely no evidence whatsoever that any money passed between Mark Sievers and Jimmy Ray Wright to murder Dr. Sievers.
No.
Your Honor, I'd like to object to the form of that last question. I think the question was that there was no information that money passed between Mark Sievers and Jimmy Ray Wright. That's what the question was.
I'll correct that, Judge.
Okay.
I said my client, Jimmy Ray Rodgers. Did you know who I was talking about, Lieutenant Lebid?
I know what you mean. You're correct.
And isn't it true that there's absolutely no evidence of any money passing between Curtis Wright and Jimmy Ray Rodgers to kill Dr. Sievers?
Correct.
And other than Mark Sievers and Jimmy Ray Rodgers attending Curtis Wright's wedding, there's no link between Jimmy Rodgers and Mark Sievers at all.
Correct.
There's actually no evidence that Jimmy Ray Rodgers ever even met Dr. Teresa Sievers.
Correct.
They didn't know each other.
Not that I've been able to find out.
The only link between Jimmy Rodgers and the Sievers, Mark and Teresa, is lying, deceitful.
Objection. Counsel is editorializing.
Sustained.
The only link between Mr. Rodgers and the Sievers is Mr. Wright,
Correct.
someone who you characterized earlier as being a deceitful person.
You offered it, and I agreed with you.
Must make it true. Ms. Schumacher, you had minimal dealings with Ms. Schumacher, correct?
That's fair to say. Minimal dealings with Miss Schumacher.
That was primarily your partner, Lieutenant Downs.
Mostly.
Now, when you say that Ms. Schumacher re-engaged with you and Lieutenant Downs, when did that happen?
It was in August. I believe it was the 25th when we were at her residence.
That was at the residence?
At her residence.
Okay.
At Miss Showmaker's residence.
And she contacted you?
We were there at her house, and we were speaking with her.
How did she re-engage?
Detective Downs could testify to that. I was not there when she initially started speaking to him.
Now, Ms. Schumacher receives money from the Witness Assistance Fund, correct?
Correct?
And how much money is that per month, do you know?
I'm not 100%, but I think it's around $400.
Okay. And she's been receiving that since February of 2016?
That sounds correct.
And that money was provided to her to assist her in relocating?
Yes.
Do you know where she relocated to?
No.
So you don't know if she's in the same town, left the state of Missouri?
I'm not 100% on her exact location because I don't deal with that portion of this investigation.
Okay. When you take statements from people in an investigation, you record them.
I try to.
Okay. That's a policy that's set down by the Lee County Sheriff's Office.
Yes, that's one of our policies when we're documenting evidence.
Okay. And you're at a very high level in the agency. I don't guess that you make a habit out of violating policies of the Lee County Sheriff's Office, correct?
Correct.
You took a lot of statements in this case.
We did.
You personally, you interviewed Tyler Juliet, correct?
Correct.
Angela Wright,
Yes.
Angela Palazzolo,
Correct.
Charles Ray,
Correct.
and Curtis Wainwright 6 times, just Mr. Wright.
Somewhere around that.
Okay. Tyler Juliet recorded.
Yes.
Angela Wright recorded.
Yes, there's other times where she would call us, but there was no time to, it was more of just speaking with her.
Okay. Palazzolo recorded.
Yes.
Charles Ray recorded.
Yes.
Curtis Wright, the first time recorded.
Yes.
Second time recorded.
Yes.
Third time recorded.
Yes.
Fourth time.
Yes.
Fifth.
Yes.
Sixth time.
Not recorded.
Okay. The 6th time was not recorded. 5 times were recorded.
Yes.
Was he videoed rather than recorded audially or on an audio tape?
It varied based on what was available at the time.
Okay. And yet this statement allegedly made to you by Mr. Rodgers, that wasn't recorded.
Correct.
6 statements, 5 from Mr. Wright were all recorded, but not this single alleged statement made by Mr. Rodgers.
Objection, asked and answered. And argumented.
Sustained as asked and answered.
Have a moment, Judge.
Yes, sir.
Do you know very much, what exactly do you know about the Witness Assistance Program, Lieutenant?
I know minimal information. I know that there's a committee that meets on determining what's approved and what's not.
Are you on that committee?
I am not.
Is this a program that you've used many times in the past?
No.
Have you ever used it in the past?
No.
So Taylor Schumacher is receiving money, thousands of dollars, and that's rather unusual in your experience.
I can't say that.
In your experience.
I'm not very familiar with it.
So you don't know very much about the program itself, only that Ms. Schumacher is provided a regular income from the county as a cooperating witness in this case.
Yes.
Nothing further, Judge.
State.
Your Honor, we need to approach.
Okay.
Lieutenant.
1 minute. Just wait for counsel to get situated. Okay.
Your September 10th visit with Mr. Rodgers. The visit where he said he was okay with that. He walked away. That one. Did you have an opportunity to get out your recorder and record your discussion with Mr. Rodgers?
No.
In fact, he appeared at the window before you had a chance to get prepared to take the statement?
Correct.
Then the discussion happened, and he was gone before you had a chance to pull out the recorder and record the statement.
Correct.
Did you want to record the discussion?
Absolutely.
Now, the previous discussion at Mr. Rodgers' home, did you want to record that statement?
Yes.
The one where he said he hadn't been to Florida?
Yes.
And Mr. Rodgers didn't want that one recorded?
Correct.
But Mr. Wright was recorded?
Yes.
He didn't stop you from recording him?
No.
He was just untruthful?
Yes.
Not that that makes it any better. Mr. Wright admitted to hitting Dr. Sievers with a hammer. You said that on cross. Did he? Was he the only person who hit Dr. Sievers with a hammer?
Objection, Judge.
Well, we've gotten out part of the statement, but not all of it.
Sustained.
You said that Mr. Wright admitted to beating Dr. Sievers. Did he give you all the details of how Dr. Sievers died?
Yes.
Objection, Your Honor. May we approach?
Okay.
Let's back up to talking about the scene. The blood that was present in the scene, did it indicate to you whether or not Dr. Sievers died where she lay in her home?
It did.
Objection.
And certainly the fact that a person is found bludgeoned to death, is that indication of a struggle?
Yes.
And here in Lee County, you're a Lee County Sheriff's deputy, right?
Yes, I am.
The Lee County Sheriff has jurisdiction over the entire county.
Yes.
Does the Lee County Sheriff investigate all homicides in Lee County?
The majority of them that were assigned, unless a municipality takes it on.
So, for example, Fort Myers, the city of Fort Myers is a municipality.
Yes.
If they investigate a homicide, then the Lee County Sheriff's Office might not be involved in that homicide investigation.
Correct.
What about the city of Cape Coral?
Same thing.
So the Lee County Sheriff may not be the lead agency of investigation on every homicide in Lee County.
Correct.
Safe to say a hammer is a blunt object,
Yes.
and hitting somebody in the head is beyond its intended use,
Yes.
no matter who wields it.
Yes.
Now, you said earlier that Mr. Wright, I think the term used between you and counsel was truthful when convenient. At some point now, when Mr. Wright gave you these statements where he admitted to his involvement in the beating of Dr. Sievers, was the information he gave you at that point corroborated? Were you able to independently corroborate what he was saying?
Objection, Your Honor.
Overruled.
Yes.
Did the sheriff's office during the investigation also look into the Sievers banking records?
Yes.
And those records would have been their personal banking as
I'm going to object. This is well beyond the scope of your cross-examination.
counsel asked about payments to Mr. Wright on cross.
Overruled.
Did the sheriff's office obtain subpoenas for bank records regarding the Sievers personal banking as well as business banking?
Yes.
And the Sievers medical practice had a business banking account?
Yes.
When you initially spoke to Mr. Wright in Missouri, and he, as you discussed earlier, lied to you, did he put anybody involved in the death of Dr. Sievers?
No.
He concealed all involvement.
Yes.
Thank you.
Oh, wait.
The conversations that you had with Mr. Rodgers, would you agree that Mr. Rodgers didn't do anything to stop you from recording that conversation? That was poor planning on your part.
You're referring to both conversations?
Yes.
The first conversation, we met him because he was in a phone log and we were trying to establish a timeline, and he declined to provide a sworn statement. So we said, okay, have a good day, and we left. And then the second time, I did not have the opportunity to do that.
So it wasn't that Mr. Rodgers prevented you from recording the statement. You just weren't ready to record the statement.
That's correct. I was not ready.
Now, following up on Mr. Hunter, there was a struggle at the Jarvis house, but it was only in the kitchen, correct?
That's what it appeared as.
Okay, thank you.
Nothing further, Judge.
This witness to be released or retained?
he's free to go from the state.
No objection.
Thank you, Lieutenant. You're free to go.
Thank you, Your Honor.
Next witness.
This time the state calls Mr. Labinski. Mr. Labinski.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Labinski, would you state your full name for the record, please?
Jerry Labinski,
And would you spell your last name for the court reporter, please?
Lubinski.
You know, Mr. Labinski, you just celebrated a birthday recently, didn't you?
Yes, ma'am.
Would you mind sharing with the jurors how old you are, or would you prefer not to?
80.
Are you retired?
Yes.
Do you know Curtis Wainwright?
Yes.
And how long have you known him?
Approximately 10 years.
And how have you known, or how do you know Mr. Wright?
I met him at our church. He was the assistant youth program director.
And at the time that you met him, were you married? Were you married to your wife who later passed away?
Yes, I was married to Joyce.
And would Mr. Wright come over to your house?
Yes, he did.
Now, did Mr. Wright do any work for you?
Yes.
What type of work did he do for you?
First off, he did work. I had a sporting goods company, and I was getting ready to set it up to sell, and he would come over to do the books and set up on programs on a computer for my inventory. And then he also did put a deck on my house. He did a lot of little stuff for me.
And would you pay him for this when he did that?
Yes.
Now, did there come a time when Mr. Wright was getting married?
Yes.
And did you attend that wedding?
Yes.
I want to show you what's been marked for identification as state 74 A, B, C, and D. You would just look at them for a moment, and then I'll ask you a few more questions. Thank you. Are those photos from Mr. Wright's wedding to Angie Wright?
Yes.
And do you recognize the people in those photos?
All but one.
Move to introduce 74A through D.
Objection.
We'll show them admitted.
Permission to publish, Your Honor.
You may.
Mr. Lebinski, I'm going to publish them, which means the jury will be able to see them, and they're going to be up on this screen. Gosh, terribly sorry, Mr. Pacell. Mr. Lebinski, I'm showing you what's been introduced into evidence as State's Exhibit number 74A. Do you recognize the people in 74A?
Yes.
Who are the people in 74A?
On the right is Wayne, and on the left, I think his name is Mark.
So is Wayne the person I've referred to as Mr. Wright?
Yes, I call him Wayne.
And did you meet the person on the left who you just referred to as Mark? Did you meet him at the wedding?
Yes, I did.
And did you later learn that his full name was Mark Sievers?
Yes.
Let me show you what's been marked as 74B. Excuse me while I flip the camera. you recognize the two people in that photo?
Yes, Wayne is on the left and Mark is on the right.
Do you recognize the people in 74C?
I only recognize three of them, Angie, Wayne, and Mark.
Now, is Angie Wayne Wright's wife the individual he married that day?
Correct.
And could you just, is she the woman who's standing directly in the middle?
Yes.
And who is standing to her right-hand side?
Wayne's to her left, right as I look at the picture, and Mark's at the end.
And then finally, I want to show you, State's Exhibit 74D. Again, do you recognize who's in that photo?
Yes.
And who's in that photo?
Wayne and Mark. Wayne's on the left, Mark's on the right.
Thank you. Did there come a time in June of 2015 where you, and I guess it was your then, the woman you were, who's now your wife, did you have Mr. Wright and Angie Wright over to dinner?
Yes.
And during that, well, let me back up just a moment. Had you ever lent Mr. Wright a garment so that he could find
Yes.
his way?
Yes.
And was there a dinner where he and his wife were present in June where you asked if he could give you back your garment?
Yes.
And what happened when you asked him if he could give you back your garment?
We were getting ready to go to a trip in Florida and asked for it back to use it. And Mr. Wright asked me, he says, I have quite a bit on the garment.
Just a moment, Mr. Labinski.
Overruled.
You may continue, sir.
That he had quite a bit on the garment. And he, Wayne had like a short-term memory. And he wanted to make sure that he kept everything on there. So he asked me if I could buy a new one. And I said yes. And so in exchange for that, like I used to do for his camera and his computer, when he needed something like that, I said, well, here's the money, get it, and we'll work it off. So I asked for it back, and we went to buy a new one.
And then when you would do something like that, would he then do some work for you so that would be in payment?
Yes.
For that? Now, during that time at your house, did Mr. Wright indicate that he was heading to Florida?
Yes.
And if you can recall back to the time towards the end of Florida, can you put it in terms of how close that was to the time when he actually went down to Florida?
Approximately maybe a week to 3 days, somewhere in that time frame.
At Wayne and Angie's wedding, did you meet Mark Sievers?
Yes.
I have no further questions of this witness. Thank you very much.
Defense.
Hello, Mr. Labinski.
Hello.
You indicated that Mr. Wright, Wayne, had told you he was going to Florida. Is that right?
Yes.
In fact, did you know Mr. Wright to go to Florida on occasion?
Yes.
And did you know why he went to Florida on occasion?
He did some computer work. He also put security systems in.
Do you know if he did computer work and put security systems in for Mr. Sievers?
Yes.
Did you know Mr. Wright to have blackouts during driving, while he was driving?
No.
Mr. Labinski, do you remember meeting with me on November 26th last year, 2018, in Missouri?
Yes.
Okay. And I took your deposition at that time?
Yes.
Okay. Do you recall your answer to that question about blackouts when you were asked a question at that time?
I could have. I don't remember.
Okay. Oh, excuse me. Okay. Referring to his deposition, page 14. Okay, I'm going to withdraw that question. You stated that something about Mr. Wright's short-term memory. What did you mean by that?
Mr. Wright's a very intelligent man, and especially with the computers and that. And the work I had him do, besides at my business I sold, he set me up on eBay. I sell antiques, and what I mean by that is that he's very good at doing one thing. Like, just that's it, and you don't bother him. And he was supposed to be teaching me, and he'd go like that and forget it. But that's what I mean of a short term. You know.
So he was pretty focused on something?
Yes.
Okay. Okay. Normally when Mr. Wright would go to Florida, did you know about it?
Majority of the times, yes.
Did he tell you why he was going?
Sometimes, yes. Almost all the times, yes.
Sometimes yes. Okay. You also mentioned that about the Garmin that he had borrowed from you.
Yes.
And used it, and you said that Mr. Wright asked if he could buy you a new one. Is that right?
Correct.
Okay. Would you allow him to kind of work off a trade or barter with you?
Yes, we did. Several things.
Several other things in addition to the Garmin?
Like a computer, a camera, saw, different things. His tools were stolen, and when he was putting a deck on my house, he needed some new tools, so we bought the tools for him that he needed.
Well, thank you very much for your testimony.
Thank you.
Just one point of clarification, Your Honor. Mr. Labinski, when Ms. Fitzgeorge was out in Missouri and speaking with you, I think.
Excuse me, objection. I withdrew my question.
Do you need to approach, or are you done?
I would have, Jeff.
Well, I'm asking the state.
I just want to make, the question left the implication he'd said something different at the time. He had not. That's all the state was trying to clarify.
She withdrew it. Okay.
Then I have nothing further.
Is this witness to be released or retained?
Released, Your Honor.
Thank you, sir. You're free to go.
Thank you.
Does any juror need a break? Okay, I saw a hand. I'll ask you not to talk about the case among yourselves with anybody else or look up any of the people or places involved, and we'll be with you after a short restroom recess.
We have a proposal for the court on how we'd like to proceed.
For the record, both assistant state attorneys are present. Mr. Rodgers is present, and all four defense counsel. Yes, sir.
Sorry, I got ahead of myself. The state is going to be seeking to introduce 3 surveillance videos. One of them is from a racetrack in Bushnell, Florida. The other one is from a Circle K in Brooksville. And the third is from Walmart here in Fort Myers. The defense has informed me that they have some objections that they want to make, and we thought that it might save the court and the jury some discomfort if the state calls the witnesses outside the presence of the jury. Maybe this is one of those days when the court can let the jury go early. We can proffer the testimony, seek to admit the items, and then if they're admitted, we can simply tell the jury tomorrow that the items were admitted and proceed. I wasn't intending to play any of the video today. And so we thought it might be a little cleaner rather than witness and then objection argument, and then witness and objection argument, and witness objection argument, and all this time while the jury's sitting here. Defense.
Judge, yes, that's correct. I don't know that I have objections, but I'll need to hear the testimony first. But I figure that this is not necessarily testimony the jury's going to need to hear. If they come in, I don't mind tomorrow them being identified, for example, as I'm going to now show you the number 29, which is a video from the racetrack on this date. That's all right in there.
How long will the testimony take?
I don't anticipate, there's a total of 6 witnesses that would probably take 5 or 10 minutes each to ask the predicate questions.
Thank you.
2 of them I will have to have come back tomorrow for additional items. But
Okay, so you guys want to release the jurors now?
I just thought that would be cleaner and probably move it quicker.
Okay, bring them out. We have a few matters we have to take care of outside of your presence still, and they will be resolved fairly quickly. However, the next witnesses may take some time, so rather than have you sit here idle, I'm going to go ahead and let you go for the day. I'm going to instruct you again not to talk about the case among yourselves with anybody else or look up any of the people or places involved. We'll see you tomorrow at 9 o'clock. 9 o'clock. Got a few other things at 8:30. I don't want you sitting there spinning your wheels.